Okay, let's get into it. This just dropped today. This was filed by Jack Smith, United States of America versus Donald J. Trump, the defendant. This is government's motion for immunity determinations. Now, Trump has been doing everything he can in the last couple weeks to delay this. He fought this. He did not want this released, but it got just released today. And I believe it's 165 pages, 180 pages. So here we go. Oh, and just a couple disclaimers. So, there's a lot of redactions, but of course, people on the internet have kind of figured out what those redactions are. So it's like CC1, CC2. So I'm going to say the CC1 and then Giuliani, which is allegedly CC1, but just understand that when I say the number and the name, it's allegedly. We don't know for sure that these are the people on the names. It's just been kind of deciphered a bit based on testimony that's already happened. So just that disclaimer, just understand that it's allegedly. We're not certain, completely certain, but there are a couple things that I do know, and then I'll kind of interject when I see that coming in. Okay. So the defendant asserts that he is immune from prosecution from his criminal scheme to overturn the 2020 presidential election because he claims it entailed official conduct. Not so. Although the defendant was the incumbent president during the charged conspiracies, his scheme was fundamentally a private one. Working with a team of private co-conspirators, the defendant acted as a candidate when he pursued multiple criminal means to disrupt, through fraud and deceit, the government function by which votes are collected and counted, a function in which the defendant, as president, had no official role. In Trump versus United States 144S CT 2312, 2024, the Supreme Court held that presidents are immune from prosecution for certain official conduct, including the defendant's use of the Justice Department in furtherance of his scheme, as was alleged in the original indictment, and remanded to this court to determine whether the remaining allegations against the defendant are immunized. The answer to that question is no. This motion provides a comprehensive account of the defendant's private criminal conduct, sets forth the legal framework created by Trump for resolving immunity claims, applies that framework to establish that none of the defendant's charged conduct is immunized because it either was unofficial or any presumptive immunity is rebutted. The requests the relief the government seeks, which is at bottom this: that the court determine that the defendant must stand trial for his private crimes as would any other citizen. This motion provides the framework for conducting the necessarily fact-bound immunity analysis required by Supreme Court's remand order, Trump 144S CT at 2340. It proceeds in 4 parts. Section 1 provides a detailed statement of the case that the government intends to prove at trial. This includes the conduct alleged in the superseding indictment, as well as the other categories of evidence that the government intends to present in its case in chief. This detailed statement reflects the Supreme Court's ruling that presidential immunity contains an evidentiary component, ID, which should be addressed at the outset of the proceeding, ID at 2334. Section 2 sets forth the legal principles governing claims of presidential immunity. It explains that for each category of conduct the Supreme Court has not yet addressed, this court should first determine whether it was official or unofficial by analyzing the relevant content, form, and context, ID at 2340, to determine whether the defendant was acting in his official capacity or instead in his capacity as a candidate for re-election. Blasingame versus Trump, 87F 4th 117 DC Circ 2023, where the defendant was acting as office seeker, not office holder. No immunity attaches. ID, emphasis in original. For any conduct deemed official, the court should next determine whether the presumption of immunity is rebutted, which requires the government to show that applying a criminal prohibition to that act would pose no dangers of intrusion on the authority and functions of the executive branch. Trump 144S CT at 2331-32, quoting Nixon versus Fitzgerald 457, US 731, 754, 1982. Section 3 then applies those legal principles to the defendant's conduct and establishes that nothing the government intends to present to the jury is protected by presidential immunity. Although the defendant's discussion with the vice president about their official responsibilities qualify as official. See Trump 144 SCT at 2336. The government rebuts the presumption of immunity, and all of the defendant's remaining conduct was unofficial. As content, form, and context show, the defendant was acting in his capacity as a candidate for re-election, not in his capacity as president. In the alternative, if any of this conduct were deemed official, the government should rebut the presumption of immunity. Finally, Section 4 explains the relief sought by the government and specifies the findings the court should make in a single order, namely that the defendant's conduct set forth in Section 1 is not immunized, and that as a result, the defendant must stand trial on the superseding indictment, and the government is not prohibited at trial from using evidence of the conduct described in Section 1. Factual proffer. Here we go. When the defendant lost the 2020 presidential election, he resorted to crimes to try to stay in office. With private co-conspirators, the defendant launched a series of increasingly desperate plans to overturn the legitimate election results in 7 states that he had lost: Arizona, Georgia, Michigan, Nevada, that's my state, New Mexico, Pennsylvania, and Wisconsin, the targeted states. His efforts included lying to state officials in order to induce them to ignore true vote counts, manufacturing fraudulent electoral votes in the targeted states, attempting to enlist Vice President Michael R. Pence in his role as President of the Senate to obstruct Congress's certification of the election by using the defendant's fraudulent electoral votes, and when all else failed, on January 6, 2021, directing an angry crowd of supporters to the United States Capitol to obstruct the congressional certification. The through line of these efforts was deceit. The defendants and co-conspirators knowingly false claims of election fraud. They used these lies in furtherance of 3 conspiracies. Conspiracy 1, a conspiracy to interfere with the federal government function by which the nation collects and counts election results, which is set forth in the Constitution and the Electoral Count Act. 2, a conspiracy to obstruct the official proceedings in which Congress certifies the legitimate results of the presidential election. And 3, a conspiracy against the rights of millions of Americans to vote and have their votes counted. I'm like, I just highlighted the whole thing and I can't get off it. There we go. Here we go. It's just making it is only letting me highlight the entire thing here. Okay, let me try one more time. I can't do it. At its core, the defendant's scheme was a private criminal effort. In his capacity, In his capacity as a candidate, the defendant used deceit to target every stage of the electoral process, which through the Constitution, ECA, and state laws included the state's notification to the federal government of the selection of the representatives electors based on the popular vote in the state, the meeting of those electors to cast their votes consistent with the popular vote, and Congress's counting of the electors' votes at a certification proceeding. As set forth in detail below, the defendant worked with private co-conspirators, including private attorneys. CC1, let me see here. CC1, I believe, is allegedly Rudy Giuliani. CC2 is allegedly John Eastman. CC3 is allegedly Sidney Powell. And I don't know what this is. And CC5 is allegedly Ken Chesbro. And private political operators, CC6. Let me just see. Hold on a minute. I think I might have CC6 here. I don't know who that is. Oh boy, it is a lot. Christina Bobb. CC6, Christina Bobb. I have her as CC6, but I also have her as potentially P19. So not sure who this is. Could be. We'll see. So anyway, and P1. So P1 is supposed to be Steve Bannon. Yep. And okay. So, and private operatives CC6 and P1. The defendant also relied heavily on private agents, such as his campaign employees and volunteers, like campaign manager P2, Bill Steppen, Stepien, deputy campaign manager Justin Clark, P3. And again, these are all allegedly. I'm just going to say them. I'm not going to repeat allegedly. Senior campaign advisor Jason Miller, P4, and campaign operator P5 Michael Roman. In this section, the government sets forth detailed facts supporting the charges against the defendant, before addressing in the next section why none of this conduct is subject to immunity under the Supreme Court's decision in Trump. The conduct set forth below includes the defendant's formation of the conspiracies leading up to and immediately following the 2020 presidential election, certain information regarding his knowledge that there had not been outcome determinative fraud in the election, as he persistently claimed and still is claiming even today on his True Social, and his increasingly desperate efforts to use knowingly false claims of election fraud to disrupt the electoral process. And then there's a little footnote here. Section 1 represents the government's efforts to provide the court and the defendant with all of the categories of evidence that it may offer and its case in chief at trial. It does not include citations to every potential exhibit, nor does it account for any additional evidence that may be developed before trial. They could come up with some more stuff. This is the put my hair up kind of document. Just saying. I'm only on page 4. Oh my God. This is a lot. Okay. The government does not consider, I don't know why it's doing that. The government does not consider any of the following conduct to be subject to immunity for the reasons set forth in Section 3. Formation of conspiracies. Although his multiple conspiracies began after Election Day in 2020, the defendant laid the groundwork for his crimes well before then. Leading into the election, the defendant's private and campaign advisors, including P6, Roger Stone, then a private citizen, and P2, Bill Steppen, the defendant's campaign manager, informed him that it would be a close contest and that it was unlikely to be finalized on Election Day, in part because of the time needed to process large numbers of mail-in ballots prompted by the COVID-19 pandemic. They also told the defendant that the initial returns on election night might be misleading. That is, that he might take an early lead in the vote count that would diminish as mail-in ballots were counted because his own supporters favored in-person voting, while supporters of his opponent, Joseph R. Biden, favored mail-in ballots. Which is interesting because he was screaming, don't do mail-in ballots. And then right at the end, he was like, mail-in ballots are good. When in fact, I believe he votes through mail-in ballot. FYI. Privately, the defendant told advisors, including P6, Roger Stone, campaign personnel P7, Mark Meadows, a White House staffer and campaign volunteer, and P8, Mark Short, the vice president's chief of staff. So this is Pence's chief of staff. Yeah, Mark Short was Pence's chief of staff. So that would probably be accurate, but again, allegedly. That in such a scenario, he would simply declare victory before all the ballots were counted and any winner was projected. Publicly, the defendant began to plant the seeds for that false declaration. In the months leading up to the election, he refused to say whether he would accept the election results, insisted that he could lose the election only because of fraud, falsely claimed that mail-in ballots were inherently fraudulent, and asserted that only votes counted by Election Day were valid. For instance, in an interview on July, oh, this is interesting. Is this going to work? No, it's not. In an interview on July 19, 2020, when asked repeatedly if he would accept the results of the election, the defendant said he would have to see, and it depends. Quotes. On July 30th, despite having voted by mail himself earlier that year, the defendant suggested that widespread mail-in voting provided cause for delaying the election, tweeting, "With universal mail-in voting, not absentee voting, which is good, 2020 will be the most inaccurate and fraudulent election in history. It will be a great embarrassment to the USA. Delay the election until people can properly secure and safely vote. Question mark, question mark, question mark. So that was an actual tweet that Donald Trump put out. That you can see the tweet right here. It's this whole, it starts here. So in an interview on August 2nd, the defendant claimed without any basis that there is no way you can go through a mail-in vote without massive cheating. So again, he's just laying this groundwork for cheating that isn't there. At a campaign event in Wisconsin on August 17th, the defendant told his supporters, the only way we're going to lose this election is if the election is rigged. Remember that. It's the only way we're going to lose this election, so we have to be very careful. So again, laying the groundwork that if he doesn't win, the only other explanation is that it was rigged. In his acceptance speech at the Republican National Convention on August 24th, the defendant said that the only way they can take this election away from us is if this is a rigged election. On October 27th, during remarks regarding his campaign, the defendant said it would be very, very proper and very nice if a winner were declared on November 3rd instead of counting ballots for 2 weeks, which is totally inappropriate, and I don't believe that that's by our laws. I don't believe that. So we'll see what happens. The defendant said this despite, or perhaps because, his private advisors had informed him that it was unlikely that the winner of the election would be declared by November 3rd. And then there's all the videos with all the evidence down here. So you can go and look through these transcripts. You can look through, this is like the actual tweet. So you can see the actual evidence right here. By October 2020, P1, I should know this by now, Steve Bannon, a private political advisor who had worked for the defendant's 2016 presidential campaign, began to assist with the defendant's re-election efforts. 3 days before election day, P1, Steve Bannon, described the defendant's plan to a private gathering of supporters. And what Trump's going to do is just declare victory, right? He's going to declare victory. That doesn't mean he's the winner. He's just going to say he's the winner. After explaining that Biden supporters favored voting by mail, P1, Steve Bannon stated further, and so they're going to have a natural disadvantage and Trump's going to take advantage of it. That's our strategy. He's going to declare himself a winner. So I'm pretty sure Steve Bannon is P1 because he actually did say these words on his podcast. I believe that was on his podcast. Might have been just to a private gathering, but it's on it's recorded. And I did hear it. So I do know that that was Steve Bannon that said that. Immediately following Election Day on November 3rd, the defendant did exactly that. As his private and campaign advisors had predicted to him, in certain states, the defendant took an early lead on Election Day that began to erode. At approximately 11:20 p.m., Fox News projected that Biden would prevail in the state of Arizona, and according to campaign advisor P4, Jason Miller, he and the defendant were shocked and angry at this development. As Election Day turned to November 4th, the contest was too close to project a winner, and in discussions about what the defendant should say publicly regarding the election, senior advisors suggested the defendant should show restraint while counting continued. Two private advisors, however, advocated a different course. CC1, Rudy Giuliani, and CC6, Christina Bobb, suggested that the defendant just declare victory. And at about 2:20 a.m., the defendant gave televised remarks to a crowd of his campaign supporters in which he falsely claimed, without evidence or specificity, that there had been fraud in the election and that he had won. This is a fraud on the American public. This is an embarrassment to our country. We were getting ready to win this election. Frankly, we did win this election. We did win this election. It's a direct quote from Donald Trump. In the immediate post-election period, while the defendant claimed fraud without proof, his private operatives sought to create chaos rather than seek clarity. At polling places where states were continuing to tabulate votes, for example, on November 4th, P5, P5, Michael Roman, a campaign employee, agent, and co-conspirator of the defendant, tried to sow confusion when the ongoing vote count at the TCF Center in Detroit, Michigan, looked unfavorable for the defendant. There, when a colleague at the TCF Center told P5, Michael Roman, we think a batch of votes heavily in Biden's favor is right. P5 responded, Mark Meadows responded, Find a reason it isn't. Give me options to file litigation, and even if it is. When the colleague suggested that there was about to be unrest reminiscent of the Brooks Brothers riot, a violent effort to stop the vote count in Florida after the 2000 presidential election, P5, Michael Roman, responded, "Make them riot and do it." The defendants, campaign operatives, and supporters used similar tactics at other tabulation centers, including in Philadelphia, Pennsylvania, and the defendant sometimes used the resulting confrontations to falsely claim that his election observers were being denied proper access, thus serving as a predicate to the defendant's claim that fraud must have occurred in the observer's absence. Contrary to the defendant's public claims of victory immediately following Election Day, his advisors informed him that he would likely lose. So his advisors were telling him, you're going to lose the election. You didn't win. On November 7th, in a private campaign meeting that included P2, Bill Stephan, P3, Justin Clark, P4, Jason Miller, and White House staffer P9, Greg Jacob, who is a White House lawyer. Again, these are all allegedly, let me just remind you, who came to serve as a conduit for information from the campaign to the defendant. Campaign staff told the defendant that he had only a slim chance of prevailing in the election and that any potential success was contingent on the defendant winning all ongoing vote counts or litigation in Arizona, Georgia, and Wisconsin. Within a week of that assessment, on November 13th, the defendant's campaign conceded its litigation in Arizona, meaning that based on his campaign advisor's previous assessment, the defendant had lost the election. That same day, in an implicit acknowledgement that he had no lawful way to prevail, the defendant sidelined the existing campaign staff responsible for mounting his legal election challenges. So I think what that means, sidelined, I think that means that Donald Trump kind of pushed his campaign staff to the side because they were responsible for mounting his legal election challenges. I'm not sure what that means. Maybe somebody smarter than me can tell me. So from P2, Bill Stephan, and P3, Justin Clark, and others who were telling the defendant that the truth that he did not want to hear, that he had lost, the defendant turned to CC1, Rudy Giuliani, a private attorney who was willing to falsely claim victory and spread knowingly false claims of election fraud. So basically, I think he fired the first couple because they were telling him the truth and he didn't like it. So then he went to Rudy Giuliani, who was being a yes man, I guess. So as the defendant placed alternating phone calls to P3, Justin Clark, and CC1, Rudy Giuliani, throughout November 13th, P1, Steve Bannon, informed CC6, Christina Bobb, another private campaign advisor, of the change, writing, "Close hold, don't tell anyone Trump just fired P3, Justin Clark, and put CC1, Rudy Giuliani, in charge." So he did. He fired these other ones that were being honest, and then he put Rudy Giuliani in charge. But it looks like Steve Bannon and Christina Bobb, Steve Bannon informed Christina Bobb that of that change in writing and said, "Don't tell anyone that Trump fired him." Interesting. Okay. And then here's the evidence if you want to see it. I'll definitely post the link to this document as well underneath. So if you guys want to look at anything for yourselves, you can. All right. You are to report to CC1, Rudy Giuliani. When CC6, Christina Bobb, asked if P2, Bill Stephan, was gone too, P1, Steve Bannon, replied that they are all to report to CC1, Rudy Giuliani, and that P1, Steve Bannon, had made a recommendation directly that if CC1, Rudy Giuliani, was not in charge of this thing, this thing is over. Trump is in to the end. The next day, consistent with P1, Steve Bannon description, the defendant announced his staff change by tweet, writing, "I look forward to CC1, Rudy Giuliani, spearheading the legal effort to defend our right to free and fair elections," in all caps. CC1, Rudy Giuliani. P10, Joseph DeGenova, a lawyer. P11, Victoria Toensing, and CC3, Sidney Powell, and P12, Jenna Ellis, allegedly. A truly great team added to our other wonderful lawyers and representatives. Probably pretty easy to find out if we just go look at his tweet, because the names are probably in the tweet. All right, the defendant knew that his claims of outcome determination fraud were false. Following Election Day and throughout the charged conspiracies, the defendant, his co-conspirators, and their agents spread lies that there had been outcome determinative fraud in the election and that he had actually won. These lies included dozens of specific claims that there had been substantial fraud in certain states, such as that large numbers of dead, non-resident, non-citizen, or otherwise ineligible voters had cast ballots, or that voting machines had changed votes for the defendant to votes for Biden. And the defendant and co-conspirators continued to make these unsupported, objectively unreasonable, and ever-changing claims even after they had been publicly disproven or after advisors had directly informed the defendant that they were untrue. The evidence demonstrates that the defendant knew his fraud claims were false because he continued to make those claims even after his close advisors, acting not in an official capacity but in a private or campaign-related capacity, told him they were not true. These advisors included P9, Greg Jacob, White House lawyer, the White House staffer and campaign conduit, and Pence, the defendant's running mate. P9, Greg Jacob, relationship with the defendant began before P9, Greg Jacob, worked for him in the White House. P9, Greg Jacob, had known P13, Jared Kushner, the defendant's son-in-law, since P13, Jared Kushner, was a child. And through P13, Jared Kushner met P14, Ivanka Trump, and then the defendant. P9, Greg Jacob, was one of several attorneys who represented the defendant in his first impeachment trial in the Senate in 2019 and 2020, including presenting argument on the Senate floor on January 27, 2020. P9, Greg Jacob, began working in the White House as an assistant to the president in August 2020. In October 2020, P9, Greg Jacob, White House lawyer, became interested in learning more about the defendant's campaign, and in early November 2020, after he began interfacing with campaign staff, P9, Greg Jacob, consulted with the White House's counsel's office to ensure he complied with any applicable laws regarding campaign activity. Therefore, and throughout the post-election period, P9 became a conduit of information from the campaign to the defendant, and over the course of the conspiracies, P9, Greg Jacob, told the defendant the unvarnished truth about his campaign legal team and the claims of fraud that they and the defendant were making. Examples of these include P9, Greg Jacob repeatedly gave the defendant his honest assessment that CC1, Rudy Giuliani, could not mount successful legal challenges to the election. For instance, when the defendant told P9, Greg Jacob, that he was going to put CC1, Rudy Giuliani, in charge of the campaign's legal efforts, but pay him only if he succeeded, P9, Greg Jacob, told the defendant he would never have to pay CC1, Rudy Giuliani, anything. In response, the defendant laughed and said, "We'll see." Therefore, in Oval Office meetings with the defendant, CC1, Rudy Giuliani, and others in which CC1, Rudy Giuliani, made speculative claims, P9, Greg Jacob, also told CC1, Rudy Giuliani, in front of the defendant that CC1, Rudy Giuliani, would be unable to prove his allegations in a courtroom. In a separate private conversation with P9, Greg Jacob reiterated to the defendant that CC1 would be unable to prove his false fraud allegations in court. The defendant responded, "The details don't matter." Oh my God, that's crazy. Whew, I gotta get a little more comfortable here, guys. Okay, in the post-election period, P9, Greg Jacob, also took the role of updating the defendant on a nearly daily basis on the campaign's unsuccessful efforts to support any fraud claims. P9, Greg Jacobs, told the defendant that the campaign was looking into his fraud claims and had even hired external experts to do so, but could find no support for them. He told the defendant that if the campaign took these claims to court, they would get slaughtered because all claims are all, and it's written out total, but I'm just going to shorten it because The platforms don't like this word, but it would be BS. P9, Greg Jacob was privy in real time to the findings of the two expert consulting firms the campaign retained to investigate fraud claims. C1, who is C1? Is there just a plain C1? Or is that supposed to be CC1? No, there's a C1. Hold up. I do not know who C1 is. I don't have that in the list. Let me just check one more place. Yeah, I don't have C1. C1 and C2 and discussed with their defendant their debunkings on all major claims. For example, P9, Greg Jacobs, told the defendant that Georgia's audit disproved claims that C3 had altered votes. Because I don't know what those are. I don't have them anywhere. Just double check. Yeah, I don't. Okay. In the post-election time period, Pence, the defendant's own running mate, who he had directed to assess fraud allegations, told the defendant that he had seen no evidence of outcome determinative fraud in the election. This was in one of the many conversations the defendant and Pence had as running mates, in which they discussed their shared electoral interests. Pence gradually and gently tried to convince the defendant to accept the lawful results of the election, even if it meant they lost. These conversations included a conversation on November 4th in which the defendant asked Pence to study up, in quotes, claims of voter fraud in states that they had won together in 2016 to determine whether they could bring legal challenges as candidates in those states. Pence described the conversation as follows. Well, I think it was broadly, it was just look at all of it, let me know what you think. But he told me that the campaign was going to fight, was going to go to court and make challenges. And then he just said, we're going to fight this and take a look at it. Let me know what you think. A call between the defendant and Pence on November 7th, the day the media organizations began to project Biden as the winner of the election. Pence tried to encourage the defendant as a friend, reminding him, you took a dying political party and gave it a new lease on life. A November 11th meeting among the defendant, Pence, campaign staff, and some White House staff, during which Pence asked when most of the lawsuits would be resolved. When does this come to a head? And the campaign staff responded the week after Thanksgiving. At a November 12th meeting among the defendant, Pence, campaign staff, and some White House staff, during which Pence recalls the campaign lawyers gave a sober and somewhat pessimistic report on the state of election challenges. A private lunch on November 12th in which Pence reiterated a face-saving option for the defendant. Don't concede, but recognize the process is over. Trying to save face, trying to, a private lunch on November 16th in which Pence tried to encourage the defendant to accept the results of the election and run again in 2024, to which the defendant responded, I don't know, 2024 is so far off. A November 23rd phone call in which the defendant told Pence that the defendant's private attorney, P76, here's a new one. I don't know if I have that one. Let me see. I do. Sidney Powell. So Sidney Powell is in here a couple times. So I'm not sure which one that is. We've got a couple for Sidney Powell. So could be not. It's we don't know because these are redacted. So was not optimistic about the election challenges. So whoever this private attorney was of his was not optimistic about the election challenges. A November 21st private lunch in which Pence encouraged the defendant not to look at the election as a loss, just an intermission. This was followed later in the day by a private discussion in the Oval Office in which the defendant asked Pence, what do you think we should do? Pence said, after we have exhausted every legal process in the courts and Congress, if we still came up short, the defendant should take a bow. Discussions in which Pence apprised the defendant of conversations he had had with governors in Arizona and Georgia in the context of election challenges, in which Pence had called the governors simply to gather information and share it with the president, and in which the governors did not report evidence of fraud in the elections in their states and explained that they could not take actions to convene their states' legislatures. FYI, these were Republican governors that were saying there's no evidence of fraud. And they told that to Pence, and Pence relayed that to Donald Trump. But the defendant disregarded P9, Greg Jacobs. I should know this one by now, but let me just double check. Yep, Greg Jacob. And Pence in the same way that he Okay, so the defendant disregarded P9 and Pence in the same way that he disregarded dozens of court decisions that unanimously rejected his and his allies' legal claims, and that he disregarded officials in the targeted states, including those in his own party, who stated publicly that he had lost and that his specific fraud allegations were false. Elections officials, for instance, issued press releases and other public statements to combat the disinformation that the defendant and his allies were spreading. At one point, long after the defendant had begun spreading false fraud claims, P15, an assistant to the president and director of the Oval Office operations, Nicholas F. Luna, a White House staffer traveling with the defendant, overheard him tell family members that it doesn't matter if you won or lost the election, you still have to fight like hell. Okay, so let's just go back over this statement, because this is some crazy pants stuff right here. So there was over 56 lawsuits that Donald Trump took to the legal courts, and they all said there was no fraud because they didn't come up with any allegations. There was no allegations, and Donald Trump actually paid, I believe he paid his own investigators upwards of $700,000 to find evidence, and they didn't find any. And many of these courts were Republican judges, and it's not like not all court, 100% are not kangaroo courts. I mean, this is really, really crazy stuff here. And really obvious if you start to really look at the evidence here, that people in his own party were telling him that publicly, saying that he had lost and there was no specific fraud allegations, that they were false, that the fraud allegations were false. It's been proven in court over and over and over again. All right. By his own people, being told, and the majority of the defendants are Republicans and his own people. So what really amazes me is that, it's always somebody else's fault. It's never his fault. He's the victim, and everybody's against him. Either that's the truth or he's lying. All right. So the defendant and his co-conspirators also demonstrated their deliberate disregard for the truth, and thus their knowledge of falsity, when they repeatedly changed the numbers in their baseless fraud allegations from day to day. So they were changing their own numbers in their own fraud allegations. At trial, the government will introduce several instances of this pattern in which the defendant and co-conspirators' lies were proved by the fact that they made up figures from whole cloth. One example concerns the defendant and co-conspirators' claims about non-citizen voters in Arizona. The conspirators started with the allegation that 36,000 non-citizens voted in Arizona. 5 days later, it was beyond credulity that a few 100,000 didn't vote. 3 weeks later, the bare minimum was 40 or 50,000. The reality is about 250,000 days after that, the assertion was 32,000, and ultimately the conspirators landed back where they started at 36,000, a false figure that they never verified or corroborated. So the number was 36,000, then it was a few 100,000, and then it was 40 or 50,000, and then the reality is 250,000, and then days after that they went back to 32,000 and then came back to their original 36,000 number. So they kept changing the numbers of what the falsity was, and then never came up with any proof. Ultimately, the defendant's steady stream of disinformation in the post-election period culminated in the speech he gave at a privately funded, privately organized rally at the Ellipse on the morning of January 6, 2021, in advance of the official proceedings in which Congress was to certify the election in favor of Biden. In his speech, the defendant repeated the same lies about election fraud in Arizona, Georgia, Michigan, Nevada, Pennsylvania, and Wisconsin that had been publicly or directly debunked. The defendant used these lies to inflame and motivate the large and angry crowd of his supporters to march to the Capitol and disrupt the certification proceeding. Okay, I'm going to pause there, and I'm going to come back to this tomorrow, and I'll keep doing it. But we're on C. The defendant aimed deceit at the targeted states to alter their assertion and appointment of electors, and we are on page 16. We're only on page 16. We got a lot to go, guys. Okay. I'll see you soon.